Los Angeles, 1965. A man steps into a glass phone booth on a busy sidewalk, pulls the door shut behind him, and drops in his coins. He believes he is alone. He is wrong. Taped to the top of that booth, on the outside, is a small microphone the FBI put there, quietly recording every word he says. The agents never open the door. They never set foot inside. They never lay a finger on him. 2 years later, the Supreme Court will look at what those agents did and call it an illegal search. And in the same stroke, tear up a rule that had stood for nearly 40 years. This is the case that decided the Constitution protects people, not places. For most of American history, the Fourth Amendment was about physical space. Your home, your papers, your property. The government could not come in and search them without a warrant, and the rule was nearly that literal. If the police did not physically intrude into a protected place, there was no search at all. But a phone call breaks that picture. Your most private words leave your mouth and travel down a wire, out of any room you could ever lock. So what protects them? Over the next 12 minutes, the hidden microphone that started it, the old rule it broke, and the single sentence that moved the Constitution from guarding places to guarding people. The man in the booth was named Charles Katz. In Los Angeles in 1965, he was running a betting operation, taking wagers and passing gambling information over the phone. To keep it quiet, he did the careful thing. He did not make those calls from home. He walked to a row of public phone booths on the street and placed them from there. The FBI had come to suspect him, and the agents wanted proof in his own voice. Katz placing the bets himself. The trouble was how to get it. They could not squeeze into the booth beside him, so they tried something the law had never squarely tested. They waited until Katz left, and then they went to work on the booth itself. On the outside surface, up on top, they fixed a small electronic device, a microphone wired to a recorder. When Katz came back and placed his calls, the machine caught his end of every conversation while the agents sat nearby and listened. They never opened the door. They never reached inside. Everything they took off the outside of the glass. It worked. The tapes caught Katz passing wagering information across state lines to bookmakers in Miami and Boston. He was charged under a federal gambling law. At trial, the government played the recordings against him, and he was convicted. Katz appealed, and the fight narrowed to one strange question. Not whether he did it. The tapes were clear on that. The question was whether the government should ever have been allowed to make them. To see why that was hard, you have to know the rule the courts were living by. For nearly 40 years, the Fourth Amendment had been tied to physical trespass. The rule came from a 1928 case called Olmstead. Federal agents there had tapped a bootlegger's phone lines, but they did the tapping from wires out on the street without ever entering his house. The Supreme Court said that was fine. No trespass into a protected place meant no search. For decades, the test stayed almost mechanical. Did the government physically intrude? If it did not, the Fourth Amendment simply did not apply. By that rule, the agents watching Katz had done nothing wrong. They never entered the booth. They never broke the glass. They fixed a device to the outside and gathered sound out of the open air. No trespass, and so by the old logic, no search at all. But push on that, and it starts to feel wrong. Katz had done everything a person can do to be private. He stepped inside. He shut the door. He paid for the call. The whole purpose of that little glass room is to have a conversation the sidewalk cannot hear. If the government can record you there simply because it never touched the walls, then your privacy hangs on a technicality, on where a microphone sits, not on what you reasonably expected. And tying privacy to places carried a stranger flaw. A phone booth is made of glass. Anyone walking past can see you standing inside. If Fourth Amendment protection depended on being hidden from view, a see-through booth would protect almost nothing. Yet what Katz wanted to keep private was never how he looked. It was what he said. So which was it? A clever piece of surveillance that broke no rule because nobody trespassed, or a search of a private conversation dressed up as something else? On December 18, 1967, the Supreme Court gave its answer. 7 justices to 1. The opinion came from Justice Potter Stewart, and it did not merely decide Katz's case. It rewrote the ground rules. Stewart began by throwing out the old question, The government kept arguing about the booth. Was it a protected place? Was it public or private? Wrong frame, the court said. The Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own home, is not protected. But what he tries to keep private, even somewhere the public can see him, can be. Then came the line that decided it. A man who steps into a phone booth, shuts the door behind him, and pays the toll to place his call is entitled to assume that the words he speaks into the mouthpiece will not be broadcast to the world. Katz had not shut that door to hide his face. The glass made that impossible. He shut it to keep his words private. And that expectation, the court held, is one the Constitution protects. With that, the court retired the trespass rule. It no longer mattered that the agents had never physically entered the booth. The old Olmstead doctrine, the court said, had been worn away by later decisions and could no longer be regarded as controlling. A search did not require a break-in. It could happen through a microphone taped to the outside of a glass door. But notice exactly what the court faulted. The agents had real reason to suspect Katz. They had probable cause. They had even limited their recording to the moments he was actually placing calls. All of that, the court said, was to their credit and beside the point. Their mistake was acting on their own authority. They never carried their evidence to a judge and asked permission before they began to listen. A search run without that prior approval from a neutral magistrate, the court held, is unreasonable, almost by definition. One justice was not persuaded. Justice Hugo Black dissented alone. His argument came down to the plain words on the page. The Fourth Amendment, he pointed out, protects persons, houses, papers, and effects against search and seizure. Tangible things you can point to and carry away. A spoken conversation is none of those. You cannot seize a sentence. To Black, the majority was not so much reading the Constitution as quietly rewriting it. And rewriting it was Congress's job, not the court's. It is worth being precise about what Katz did and what it did not do. It did not ban wiretapping. It did not tell the government it could never record a suspect. The court's message was closer to the opposite. Go get a warrant. Take your suspicion to a judge, lay out your reasons, and get permission first. Do that, and surveillance like this can be entirely lawful. And the most famous part of the case is not even in the main opinion. It sits in a short concurrence by Justice John Marshall Harlan. Trying to turn the majority's reasoning into a rule other courts could actually apply, Harlan laid out a two-part test. First, a person has to genuinely expect privacy. Second, that expectation has to be one society is prepared to accept as reasonable. Harlan's phrase, a reasonable expectation of privacy, was only one justice's gloss in 1967. But in the years that followed, courts reached for it again and again until it became the standard test for what even counts as a search. When judges today ask whether the police need a warrant to track your phone, read your messages, or follow your car, they are usually asking Harlan's question. And that is both the strength of Katz and its soft spot. By anchoring privacy to what society thinks is reasonable, the court made the Fourth Amendment flexible enough to follow new technology. But reasonable is a moving target. The more ordinary it becomes to be watched, the weaker anyone's claim that a given expectation still holds. Katz freed privacy from the walls and tied it, instead, to what we are still willing to expect. So go back to that man in the glass booth, dropping his coins, pulling the door shut, certain he was alone. The agents outside never touched him, never stepped in, never broke a single thing. Under the old rule, that was the perfect trick. Surveillance with no trespass and therefore no search. The Supreme Court looked at it and said no. The Fourth Amendment had stopped guarding only walls and doors. It now guarded the person standing inside them. What made that possible was a small shift in the question. Stop asking where the government was standing. Start asking what the person reasonably expected. That single move let the Constitution keep pace with a wire, a microphone, and every listening device that came after. But eavesdropping is only one way the state can reach into your life. Sometimes it does not listen, it simply stops you. Picture a car pulled to the shoulder of a dark highway near midnight. A routine ticket, the business already done. Then the officer holds you there a little longer, waiting for a drug-sniffing dog to arrive. No new suspicion, just time. How long can the police keep you once the reason for the stop is over? That is a different corner of the same Constitution, and that is next time.